Hello, my name is Boyd Shepard, attorney at law. Today we're going to be talking about Rule 108.5 of the State Board of Dental Examiners Rules and Regulations in Texas. Before we talk about the rule, let's take a look at the wording of the rule.
Texas Administrative Code, Chapter 108, Professional Conduct, Rule 108.5, Patient Abandonment. A dentist without reasonable cause shall not abandon a dental patient. Once a dentist has undertaken a course of treatment, the dentist, absent reasonable cause, shall not discontinue that treatment without giving the patient adequate notice and the opportunity to obtain the services of another dentist. A dentist shall exercise the level of care necessary to prevent jeopardizing the patient's oral health during this process. B. Under this section, the dentist shall give a minimum of 30 days written notice of his/her intent to discontinue undertaken treatment. Notice shall be either hand-delivered to the patient or sent via certified mail. Return receipt requested to the patient's last known address, with the dentist retaining a copy of the notice letter in the patient's file along with proof of service. Adequate notice shall include the following. 1. A short description of the patient's current status, including the patient's current diagnosis and a summary of the patient's current treatment plan. 2. A short description of the patient's present and future needs. 3. An explanation regarding the consequences of non-treatment. 4. A recommendation that the patient continue care with another dentist. And 5. A clear statement emphasizing that the dentist is available to provide any emergency treatment necessary to prevent patient harm during the 30-day period. C. A dentist shall remain reasonably available to render any emergency necessary treatment under B5 of this section for up to 30 days from the date of such notice.
Rule 108.5, Patient Abandonment. Actually, the rule talks about how to avoid a complaint or an allegation of patient abandonment. Beginning with subpart A of Rule 108.5, the rule states, a dentist without reasonable cause shall not abandon a dental patient. Once a dentist has undertaken a course of treatment, the dentist, absent reasonable cause, shall not discontinue that treatment without giving the patient adequate notice. In the first sentence of subpart A, as well as in the beginning of the second sentence of subpart A, we see this phrase, without reasonable cause, and then absent reasonable cause. And what the rule is saying is, as long as there is a reasonable cause, you may dismiss the patient. And then the rule continues with how you go about dismissing the patient from your practice. Note also that it says once a dentist has undertaken a course of treatment. Sometimes patients present in the office and you haven't undertaken a course of treatment, and it becomes apparent that perhaps the patient should seek their dental treatment at another location. But once you've undertaken a course of treatment, then you must have reasonable cause. So, two questions. What constitutes the beginning or undertaking of a course of treatment? And secondly, what is considered reasonable cause? Undertaking a course of treatment, conservatively, in my opinion, is anything that allows the dentist to utilize or gather or obtain diagnostic information for the purpose of the dental record. For example, once you have obtained radiographs, even though you haven't performed anything clinically, even though you haven't undertaken a course of treatment clinically, you have gathered diagnostic information that by right should be shared with the patient. At that point, for the purposes of this rule, you have undertaken a course of treatment, and if there's a problem after the point of obtaining radiographs with the patient, then perhaps you should consider utilizing the Rule 108.5 rules for dismissing that patient if necessary. Secondly, what is considered a reasonable cause? Well, certainly a reasonable cause would include failure of the patient to present for appointments, failure of the patient to pay their fees for dental services, failure of the patient to comply with the recommendations of the treatment plan or the recommendations of the doctor with their treatment plan. If a patient becomes unruly in the dental office and creates stress or problems for the dentist or their staff, those are typical reasons for dismissing a patient. Practically, no doctor, no dentist, no dental office wants to dismiss a patient from their practice. The whole purpose is to be a healthcare provider for all of your patients. But the reality is that some patients don't comply with their treatment plan, they don't pay their bill, and they don't show up for all their appointments. And this can create a problem for the office. This is why this rule exists, because it allows the doctor to ask the patient to please seek their treatment elsewhere, but it does so in a manner that the patient is informed of the information they need to proceed down the road to find that care from the next provider. What are the requirements of the rule for dismissing a patient? Let's take a look at those requirements now. Beginning in subpart B. Under this section, a dentist shall give a minimum of 30 days written notice of his or her intent to discontinue undertaken treatment. Notice shall be either hand-delivered to the patient or sent via certified mail return receipt requested to the patient's last known address, with the dentist retaining a copy of the notice letter in the patient's file along with proof of service. Now, 30 days notice is required. You have to give 30 days notice of your intent to discontinue treatment. You have to send a certified letter, return receipt requested, which of course is a letter that has the green card attached and of which you retain a receipt in the chart stapled or attached to a copy of the letter in the patient's chart. Once you receive the green card back, that is your proof of service or proof of mailing to the patient and proof of their receipt of it. And you would then attach that to your copy of the letter in the chart as well. The rule says that you can hand deliver the letter to the patient, but my recommendation is, and in all likelihood it's more practical, to send it certified mail. That's why you need to have the return receipt so that you can show or prove delivery. The rule does require, of course, that you retain a copy of the letter in your chart, and that makes sense because you're going to want proof of what was sent to the patient and the exact wording of it. And that is the remainder of the rule. What wording, what content is required to be in this letter? So let's continue. At the end of subpart B it says, adequate notice shall include the following. 1. A short description of the patient's current status, including the patient's current diagnosis and a summary of the patient's current treatment plan. So, for this subpart 1, you would write something along the lines of, currently, your diagnosis and your current treatment plan are as follows. And then you would articulate in writing exactly what their current dental status is, their current diagnosis, and what their current treatment plan is. Number 2, a short description of the patient's present and future needs. Number 2 seems to be somewhat redundant of number 1. It seems that if you had completely fulfilled the requirement of number 1 by giving a summary of the patient's current treatment plan and current diagnosis, certainly you're discussing also what's required in number 2, a short description of the patient's present and future needs. Nevertheless, you might run these two together by following up and saying, in addition to or along with your current diagnosis as follows and your current treatment plan as follows, therefore your present and future needs are as follows. Then, number 3, an explanation regarding the consequences of non-treatment. Relative to the treatment plan and what their future and present needs are, you would advise the patient of what may occur dentally and health-wise if they do not seek continuing care. Subpart 4 requires a recommendation that the patient continue care with another dentist. Note that Subpart 4 does not require referral to another dentist. It doesn't say that you need to refer by name or specifically the patient to another dentist. It says a recommendation that the patient continue care with another dentist. In other words, in your letter you would simply make the statement, I recommend that you continue your care with another dentist. That's all that it requires, is that sentence. Finally, number 5, a clear statement emphasizing that the dentist is available to provide any emergency treatment necessary to prevent patient harm during the 30-day period. And this is reiterated or re-emphasized in the last subpart C. A dentist shall remain reasonably available to render any emergency treatment necessary under B5 above of this section for up to 30 days from the date of such notice. So the rule is saying you need to include a statement in the letter of your availability for emergencies, and then finally the rule requires you to actually be reasonably available for emergency treatment during that 30-day period. Now, with respect to the 30-day period, if you were to mail the letter on, let's say, the first day of the month, does that mean that you need to be available until the 30th day of the month, assuming that a month has 30 or 31 days? The answer is yes, certainly that, but keep in mind, certified mail under the law is recognized as taking 3 days to get from mailing to the recipient. So, my advice would be, mark your calendar not for 30 days, but for 33 days, just to be sure that you've remained available for an adequate amount of time after sending this letter to the patient, advising them that you're dismissing them from your practice. To summarize, Rule 108.5 is really a rule that gives you instructions on how to properly and legally dismiss a patient once you have undertaken treatment, and if you have what is considered reasonable cause to do so. We've articulated examples of reasonable cause to include failure to pay, failure to show for appointments, or failure to comply with the doctor's recommendations as examples. There may be other reasonable causes to dismiss a patient, and this will vary from case to case. Depending on your situation and the patient you're dealing with, you're advised to seek legal counsel to make sure that you would be compliant with this Rule 108.5 relative to whether or not you have reasonable cause to dismiss the patient. That concludes our discussion of Rule 108.5. At the end of this video, there is contact information should you have any additional questions regarding this rule or any rule of the State Board of Dental Examiners. Thank you.